2012, HSBC Bank was caught laundering money for Mexican drug cartels. Not suspected. Caught. Internal documents showed the bank had processed at least $881 million in drug trafficking proceeds. Compliance officers had been warned repeatedly. The warnings were ignored. The United States Department of Justice investigated. They decided not to prosecute. Their reasoning, stated in internal memos later obtained by journalists, was that prosecuting HSBC might destabilize the global financial system. HSBC paid a fine, $1.9 billion. That is approximately 5 weeks of revenue for HSBC. No banker was charged. No banker was fired. And HSBC signed a document in which they formally acknowledged no wrongdoing. That document has a name. It is called a settlement agreement. This is a video about 7 of them. Welcome back to Guilty and Free. There's a legal instrument used in corporate America and across Europe that has become, in practice, one of the most powerful tools for avoiding accountability ever devised. It is called a settlement without admission of wrongdoing. Here is how it works. A company is investigated for fraud, negligence, or criminal conduct. Rather than going to trial, where internal documents would become public, where executives would testify under oath, where a jury would render a verdict, the company negotiates directly with the regulator or the government. They agree to pay a sum of money. In exchange, the investigation ends. The company issues a statement, and in that statement, they include 4 words. Without admitting wrongdoing. Those 4 words are not incidental. They are the entire point. They mean the company pays the fine and simultaneously maintains, in the legal record, that it did nothing wrong. They mean no executive can be held individually liable based on the settlement. They mean the victims of the conduct cannot use the settlement as evidence in subsequent civil claims. They mean the company can do it again. Here are 7 of the most consequential cases on record. The facts of the HSBC case are not disputed. Between 2006 and 2010, HSBC's Mexican subsidiary processed at least $881 million in proceeds from the Sinaloa cartel and the Norte del Valle cartel, 2 of the most violent drug trafficking organizations in the world. To facilitate the transfers, HSBC had physically modified its teller windows in Mexico to accommodate the size of the cash boxes the cartels were using. They built bigger windows for the drug money. Internal compliance officers raised concerns. The warnings were documented. They were not acted upon. In 2012, the Department of Justice announced a deferred prosecution agreement with HSBC. The bank would pay $1.9 billion. No criminal charges would be filed. No executives would be prosecuted. The stated reason: prosecuting a bank of HSBC's size posed systemic risk. In other words, HSBC was too big to jail. The settlement contained no admission of wrongdoing. HSBC's pre-tax profits in 2012 were $20.6 billion. The fine was 9 days of profit. No HSBC executive has ever been charged in connection with the cartel money laundering. In 2010, the Securities and Exchange Commission charged Goldman Sachs with securities fraud. The specific allegation: Goldman had created a mortgage investment product called Abacus 2007-AC1, which was designed, with input from a hedge fund client, who was simultaneously betting against it, to fail. Goldman sold this product to other investors without disclosing the hedge fund's role in selecting the underlying assets. The investors lost over $1 billion. Goldman's defense was that sophisticated investors should understand the risks of complex financial products. The SEC was not persuaded. Goldman settled for $550 million. At the time, the largest penalty ever paid by a Wall Street firm in an SEC enforcement action. The settlement contained no admission of wrongdoing. In the same quarter, Goldman paid the fine. The firm reported revenues of $8.84 billion. The $550 million fine represented 6 weeks of revenue. The hedge fund client who helped design Abacus to fail, Paulson & Company, was not charged. No Goldman executive was charged. The Abacus product did exactly what it was designed to do. Between 2002 and 2016, Wells Fargo employees opened approximately 3.5 million fraudulent bank and credit card accounts in customers' names without their knowledge or consent. The scheme worked like this. Wells Fargo had created an aggressive internal sales culture that pressured employees to meet daily account opening quotas. Employees who failed to meet targets faced termination. Employees who met them received bonuses. To meet the quotas, employees began opening accounts for existing customers without telling them. They transferred small amounts of money between accounts to generate the appearance of activity. They enrolled customers in fee-charging services they had never requested. Customers began noticing unexplained fees and accounts they had never opened. When they complained, many were told the accounts were standard and the fees were correct. The practice had been known to Wells Fargo management for years before it became public. Internal documents showed that over 5,000 employees had been fired for the practice between 2011 and 2016, while the practice continued. In 2016, Wells Fargo agreed to pay $185 million in fines to the Consumer Financial Protection Bureau and other regulators. The settlement contained no admission of wrongdoing. CEO John Stumpf initially kept his job. He later resigned. His exit package was $133 million. Wells Fargo's annual revenue in 2016 was $88 billion. The $185 million fine was 2 days of revenue. The customers whose credit scores were damaged by the fraudulent accounts received an average settlement of approximately $100 each. As covered in this series, Johnson & Johnson sold talc-based baby powder for decades, while internal documents showed their scientists had detected asbestos contamination in their talc as far back as 1971. The company's legal response to the resulting cancer lawsuits was to use a tactic known as the Texas two-step. They created a new subsidiary, LTL Management, transferred all talc liability into it, and filed that subsidiary for bankruptcy. The intent was to cap the total payout to cancer victims while leaving the parent company, Johnson & Johnson, legally protected. A federal judge blocked this maneuver. Twice. Johnson & Johnson then proposed a global settlement of $8.9 billion to resolve all current and future talc cancer claims. The proposed settlement contained no admission of wrongdoing. 38,000 people had filed lawsuits. The $8.9 billion spread across all claimants, amounts to approximately $234,000 per person for ovarian cancer, mesothelioma, and other asbestos-linked diseases. Johnson & Johnson's annual revenue is over $85 billion. The settlement remains in litigation. No Johnson & Johnson executive has been charged. The company continues to sell talc-free baby powder, reformulated after the talc version was discontinued in North America in 2020. They did not explain why they reformulated. As covered in the first video of this series, Volkswagen installed defeat device software in 11 million vehicles worldwide, allowing cars to cheat emissions tests while emitting nitrogen oxide at up to 40 times the legal limit in normal driving. The emissions fraud was not a rogue program. It was a decision made at the engineering and executive level, documented in internal emails, and sustained over years. Volkswagen's global settlement ultimately totaled over $30 billion across multiple jurisdictions, the largest automotive regulatory settlement in history. In the United States, Volkswagen paid $14.7 billion, including $10 billion to compensate vehicle owners, $2.7 billion into an environmental remediation fund, and $2 billion for emissions reduction investments. The U.S. settlement with the Department of Justice contained a guilty plea, making this the partial exception in today's list. However, the individual executives most directly responsible, including former CEO Martin Winterkorn, who's been indicted in Germany, have not faced trial. Winterkorn resigned in 2015. He received a pension of approximately $3,200 per day from Volkswagen. He has not stood trial. The settlement compensated car owners. The people who breathed the excess emissions for years in cities across America and Europe were not compensated. Their settlement was zero. We have covered the Purdue Pharma case in detail in the previous video in this series. The settlement figures bear repeating here. In 2007, Purdue Pharma paid $600 million for misbranding OxyContin. No admission of wrongdoing. In 2022, the Sackler family agreed to pay $6 billion across a broader settlement, without criminal charges, and with an attempt to receive full civil immunity that the Supreme Court ultimately blocked in 2024. Between these two settlements, approximately 600,000 Americans died from opioid overdoses. In the period between the first settlement and the second, Purdue Pharma continued selling OxyContin. The 2007 settlement did not stop the epidemic. It did not slow the epidemic. It did not require Purdue to change its marketing practices in any meaningful way. A settlement without admission of wrongdoing is, in practice, a license to continue. And that is exactly what Purdue used it as. Between 2001 and 2007, Standard Chartered Bank, a British institution, processed approximately $250 billion in transactions on behalf of Iranian clients in deliberate violation of United States sanctions against Iran. The bank was not unaware of the risk. Internal emails showed executives discussing the sanctions exposure explicitly. In one email obtained by investigators, a senior executive based in New York raised concerns about the Iran transactions. The response from a London-based executive was blunt. He told the New York executive, in writing, to consider what the United States might do with its sanctions, and used a profanity to describe his view of American regulatory authority. That email became a central exhibit in the investigation. In 2012, Standard Chartered agreed to pay $340 million to the New York State Department of Financial Services. No admission of wrongdoing. Later the same year, Standard Chartered paid an additional $327 million to the U.S. Department of Justice and other regulators. No admission of wrongdoing. Total paid, approximately $667 million. Standard Chartered's revenue in 2012 was $19.1 billion. The fine was approximately 13 days of revenue. No Standard Chartered executive was charged. The executive who sent the profane email continued working in banking. 7 cases, 7 settlements, 7 documents signed without admitting any wrongdoing. The combined fines across all 7 cases total approximately $48 billion. That sounds significant until you look at the revenues. In every single case, the fine was less than 3 months of revenue. In most cases, it was less than 2 weeks. The settlement without admission of wrongdoing is not a punishment. It is a business expense. It is the cost of doing a certain kind of business, calculated in advance, priced into the risk model, and paid when necessary, while the executives responsible retain their positions, their bonuses, and their freedom. There is a term for a system in which breaking the law is financially rational because the penalty is smaller than the gain. That term is regulatory capture. And it is the operating model of the modern corporate state on both sides of the Atlantic. This is guilty and free. 7 settlements, 0 admissions, 0 prison sentences. They got away with it. Subscribe. New video every week. The next video in this series asks the question this one raises. If the fines never stop the behavior, what would?